Dear friends, this is your RAPETI SURYANARAYANA advocate from Visakhapatnam. In the earlier class, I explained about kinds of evidence, oral evidence and definition part of documentary evidence. In this class, I would like to discuss with regard to documentary evidence in a detailed manner. Chapter 5 of Indian Evidence Act deals with documentary evidence. In the earlier class, I said that as per section 59, all facts except contents of documents or electronic records may be proved by oral evidence. That means except contents of documents or electronic records may be proved by oral evidence. Then these contents of documents may be proved by what? The contents of documents may be proved either by primary evidence or by secondary evidence as per section 61 of Indian Evidence Act. Whereas in case of section 59, all facts except contents of documents or electronic records may be proved by oral evidence. That means all facts may be proved by oral evidence except contents of documents or electronic records. These contents of documents can be proved either by primary evidence or by secondary evidence as per section 61 of Indian Evidence Act. Now let us discuss what I mean by primary evidence. Primary evidence means the document itself produced for the inspection of the court. Primary evidence means the document itself produced for the inspection of the court. If the document is executed in several parts, each part is primary evidence of the document. If the document is executed in counterparts, each counterpart is being executed by one or some other parties, then each counterpart is primary evidence against the parties executing it. Each counterpart is primary evidence against the parties executing it. Whereas in before condition, each part is primary evidence of the document. Whereas here, each counterpart is primary evidence against the parties executing it. Next, where a number of documents, where there are number of documents, are all made by one uniform process. Where there are number of documents are all made by one uniform process. As in the case of lithography or photography or printing, each document is primary evidence of the contents of the rest, but not the primary evidence of the contents of the original, even though they are all copies from the common original. Even though they are all copies of common original, it is not the primary evidence of the contents of the original. It is only primary evidence of the contents of the rest, that means remaining the documents, not the original document. For example, if a person having a number of placards, all placards are printed at one time from one original. Each placard is the primary evidence of the contents of the remaining placards, but not the primary evidence of the contents of the original. even though they are all made from the one original. Whereas, while coming to discussion with regard to secondary evidence, secondary evidence means all certified copies or all copies compared with original copy or all copies made from original copy or counterparts of the documents against the parties who did not execute them, or oral accounts of the contents of documents given by some person who has himself seen it. That means oral accounts of the contents of the documents given by some person who has himself seen it. This all comes under secondary evidence. This is nothing but as per section 63 of Indian Evidence Act. Now let us discuss with regard to section 64. What the section 64 says that the documents must be proved by primary evidence. The documents must be proved by primary evidence as per section 64 of Indian Evidence Act, except in the cases in which secondary evidence relating to documents may be given. That means as per section 64 says that the documents must be proved by primary evidence in almost all the cases, but there is an exception in this, except in the cases in which secondary evidence relating to documents may be given. That means the secondary evidence relating to documents may be given in what circumstances or what exceptions. These circumstances or exceptions are stated in the section 65 of Indian Evidence Act. Section 64 says that the document must be proved by only primary evidence. Then exceptions for the production of secondary evidence are stated in section 65 of Indian Evidence Act. Now let us discuss section 65 of Indian Evidence Act. In the section 65 of Indian Evidence Act says that secondary evidence may be given of with regard to existence, condition, content of original document when the original is in the possession of the person against whom the document is sought to be proved, or when the original is in the person is legal to bound to produce before the court, or when the original is in the person is out of the reach of the process of the court, or not able to produce by the process of the court. In these circumstances, as per section 66 of Indian Evidence Act, we have to give the notice to the person to produce the original document before the court. If that person does not produce the original document before the court, then as per section 65 of Indian Evidence Act, we can produce secondary evidence. any secondary evidence. Why? Because the original is within the person. That person is not producing before the court. How, even after giving notice, as per section 66 of Indian Evidence Act, then the person having a liberty to produce secondary evidence before the Honorable Court. This one is one exception. Another one, when the original document is in the possession of a person and that person admitted in writing that he had a document, then the admission in written form is sufficient to prove that the original document is in custody of the particular person. This is one circumstance. Next one, when the original is destroyed or lost, or when the opportunity is given to produce the original document within a reasonable time, but he did not produce before the court in a reasonable time, then in these circumstances also the secondary evidence can be produced before the Honorable Court. Let us go to the next one. When the original is of a nature of not to be easily movable. That means the original can't be moved easily. Then what we have to do? In these circumstances also, we can produce secondary evidence before the Honorable Court. Next is, when the original is a public document, as per section 74 of Indian Evidence Act, then what we have to do? Then we can produce certified copy of that original document. In these circumstances. Next one. When the original is your document, and the certified copy of that document is permitted by the Evidence Act or by any law force in India to be given as evidence in court of law. In these circumstances also, secondary evidence is admissible. Next one. When original contains numerous accounts or documents. When the original contains numerous accounts or documents, then it cannot be conveniently examined by the court. Then the court what will do? If the original contains numerous accounts or documents, then court cannot be conveniently examine the document. Then what the court will see? The fact has to prove. The fact has to prove is the general result of whole collection of the documents. The fact to be proved is the general result of whole collection of the documents. That means the evidence of general result of whole collection of documents is to be produced before the court. Why? Because the court cannot conveniently examine the documents. Why? Because it contains numerous documents. So, as to the general result of whole collection of documents, the evidence should be given. Then who can give that evidence? the person who examined those documents and the person who has skilled in examination of the documents can give evidence with regard to general result of whole collection of documents. This all are with regard to the secondary evidence. I hope that it is clear to all with regard to the documentary evidence. Kindly like and subscribe my videos. Thanks a lot.